All right, I think that we can get started. So welcome everyone. This is MCEA's webinar on our most recent Supreme Court argument in front of the Minnesota Supreme Court just this morning on the PolyMet air permit. I'm Kevin Reuther, I'm MCEA's Chief Legal Officer, and with me today are Evan Mulholland, who did the argument this morning, Evan, and Ann Cohen from our office. Hi, Ann. And also joining us from Georgia is Keri Powell. Thanks for being here, Keri.
Sure.
So again, we're gathered to talk about the air permit appeal and Evan's argument from this morning. We want to talk a little bit with our experts and Evan, and then answer any questions that you have about the argument or the case or other MCEA work on PolyMet. Thank you very much for joining us. You got this invitation because you are one of our donors, and without you we can't do any of this work. We really need your financial support and we're very grateful for it, so thanks for that. We are going to be using the Q&A function in the webinar, so if you sort of hover over your screen, you should see the two bubbles at the bottom in the middle, Q and A. If you press on that, you can type your questions into that function, and I'll be monitoring that throughout our discussion today, and we'll make sure that we get to all your questions, hopefully. What we've planned is we have set aside about 45 minutes, and so we'll do some discussion of the case, and then probably we'll turn to your questions. I did want to just acknowledge to begin the amount of Clean Air Act expertise we have in the room or in the virtual room today, and to thank you guys for being here again, and just give you a couple minutes to introduce yourselves. And I want to start with our special guest, Keri Powell, who authored a really important amicus brief for us in this case. An amicus brief is a friend of the court brief. We talked about that in prior webinars. And so, Keri, can you just tell us a little bit about your background, how you got involved in the case? Thanks for being here again.
Sure. Thanks for including me. It's been a pleasure to participate in this case, and I am really hoping for your success. Again, I'm Keri Powell. I'm an environmental attorney. I work out of the Atlanta area in Georgia, and I became involved in this case when I believe it was probably Evan reached out on sort of the national networks to find an organization that might be able to participate as a friend of the court and share the bigger picture of why the issue in this case has national implications, and that it wasn't just an esoteric argument being made by an environmental group in Minnesota, but that in fact it plays a central role in implementation of the Clean Air Act nationally. So Evan and I connected, and as it turns out, in my practice, I represent an array of environmental organizations, primarily in Clean Air Act litigation and permit challenges, and sometimes regulatory challenges. And so as it turns out, we had already been making use of the Court of Appeals decision in your case in comments that we've been filing opposing permits that were being issued, and I think we'd applied it already in a permit proceeding in North Carolina and in Georgia as well. So it was great timing, and we definitely wanted to do what we could to support this case and to uphold your victory, because this was pretty much the only case out there that we could point to as a judicial affirmation of what an agency's job is when they are issuing an air pollution permit. So that's how I got involved, and my client in the case for writing the brief is the Environmental Integrity Project. EIP is a nationally focused organization, but they are dedicated to ensuring enforcement of environmental laws to protect public health and the environment. They are especially involved in air pollution permit challenges, as well as a number of other like Clean Water Act issues and things like that. But they are, I would say right now, leading organization out there to be working with more local groups in their challenges to permits like what you guys are addressing there in Minnesota.
That's great. Well, we're just really grateful that you guys were able to participate. And for those of you who watched the argument this morning, you heard multiple references to Keri's brief. So it was really wonderful to have. Evan Mulholland is our supervising attorney. He is the one who put this case together and argued it this morning. And he also is a Clean Air Act expert, which there aren't very many of. So Evan, maybe you can talk a little bit about your background.
Sure. Thanks, Kevin. And thank you guys all for coming to the webinar. I'm glad to talk to you guys and to answer questions when we get to that point. So I'm Evan Mulholland. I've been a staff attorney with MCEA for 2 years. But I worked in the Clean Air Act for many years before that, primarily in New Hampshire, where immediately prior to this position, I was the Bureau Chief of Enforcement in the Air Division in New Hampshire of the PCA equivalent, which there is called the DES. So I was working there for 2 years, and before that I was at the Attorney General's office where we did all sorts of environmental enforcement, including bringing cases for permit violations under the Clean Air Act.
Yeah, I wish that you would have had an opportunity to say that to the court this morning, that you were the Bureau Chief for Enforcement in response to a couple of those questions.
I know.
Not
in the record though.
Yeah. And then we have Ann Cohen, our senior attorney. Ann, thanks for being here. Ann is coordinating all of our mining work, including all of our work on PolyMet, and represented the Minnesota Pollution Control Agency for many, many years before joining MCEA. So Ann, can you give us a little bit of your background and experience with Clean Air Act?
Sure. Well, as Kevin just mentioned, I worked with the Pollution Control Agency for 32 years. And during that time, I did have some air cases. It wasn't a huge area of specialty for me, but I did have a case that went to trial on the issue of the potential to emit, which is a concept that is floating through this case that I will not bore you with. But basically, a lot of air cases, the fight is over, whose calculations are right, whose modeling is right, etc. And they tend to be very complicated cases. So anybody who practices in this area, in my opinion, gets a gold star for dealing with difficult material.
Thank you. All right, well, let's jump into the meat of the case. So first of all, congratulations, Evan. You did a great job this morning. I'm sure that for anybody who is watching, they will agree with me. So wonderful. I hope that you feel good about that.
Thanks,
so
Kevin.
let's just back up a little bit and maybe you can give folks the basics about what the case is about, especially for those who weren't at the argument this morning.
Sure. So what this case is about the air permit for the PolyMet mine, and the majority of the air pollution that we're talking about is coming out of the processing facility, where they take the ore and crush it and bring it down into a powder so they can separate out the metal. When they do that, that creates a lot of air pollution, mainly dust, but also other sorts of particulate and emissions from this, hundreds of yards long facility. And the question that the PCA had to answer was what's the potential to emit, like Ann said, from this facility? And if they were to run all of their machines that they already own there from the old Erie mine, they would be well over the threshold for a major source permit, which requires more stringent pollution controls and a more involved permitting. So what they did instead was apply for a cap to say they're not going to process more than 32,000 tons per day of ore at this plant. And that's called a synthetic miner permit. The problem is, though, that if the facility owners have the intention to ever go over that cap, and that the current intent is not to comply, in other words, they're going to come in a year or two and get an amendment to exceed that cap, they shouldn't have gotten that synthetic miner permit in the first place. So we informed the PCA of this problem, and they sort of didn't pay a lot of attention to it. And we appealed. The Court of Appeals agreed with us and sent this back to the agency to take a hard look at all this evidence that we submitted about the future plans of PolyMet. And so we won at the Court of Appeals. And the next step was that PolyMet and PCA asked the Supreme Court to review whether or not the Court of Appeals decision was correct.
So, excuse me, there's this term sham permitting that comes up in the case all the time. Just describe again, what does that mean? What's the allegation?
So the sham permitting allegation is that the facility has sought a permit with this cap, 32,000 tons per day cap, which keeps it out of the major source category, which is much more stringent, harder to get a permit, more process, so that it could start construction and just start up. And then soon after, we anticipate that they're going to ask for an amendment to their permit to get rid of the cap. So it's the general, the way this is supposed to work is that you're supposed to follow your cap and your permit. I mean, there's an exception if there's some changed circumstance. If you had no way of knowing something in the future, you're allowed to change it. But what you're not allowed to do is know that you're going to expand and then pretend that you're not.
So the sham
That's the
is
sham.
the sham is coming in for a permit for a smaller operation when you know all along that you're going to be expanding and emitting a lot more.
Right.
And what then was the evidence, I guess, that we submitted to the MPCA that was the case for PolyMet? I mean, what were we relying on?
So there are a couple things. The major source of our evidence was their technical report, which we've referred to a lot in the argument. This is a report that PolyMet developed and hired consultants to write for them, in which they investigated how much profit they would make under the current scheme, and then how much more profit they would make if they expanded, went well beyond the cap. And we submitted that, and we submitted some other documents explaining what that all meant.
And it showed that under their current plan, it wasn't, I mean, it's sort of profitable to you and me, 10% is profitable, but for a mining company, that's not really all that profitable.
It turns out that it's not. The rule of thumb for new mines is that they can only attract investors at 30 or 40% potential return on investment because of how risky mining is.
And that's what the expanded scenarios would provide to them. That's what the technical report
Closer,
said.
closer, up, towards 30 is what the
Okay.
the expectation was.
Okay. Good. So how did you think the argument went this morning?
I thought it went all right. I thought that the justices clearly knew what the issues were. They had prepared. They were probing both sides on, some of the weaknesses and our arguments and their arguments. And I guess we'll see how it goes. But
Yeah.
I think we did a strong job as our team in preparing for this.
So Ann and Keri, you watched the argument this morning. Any big takeaways that you want to comment on?
Sure. I agree with Evan that I think the judges understood the issues. And it seemed to me that there was a sort of a split of opinion. Some of the justices seemed to be leaning toward PCA's view of the facts, which would, be that, well, they didn't really need to look into this issue. They had been working on this for a long time. That sort of thing. But I think some of the justices really had focused on the facts. And the really interesting fact is that PolyMet's current project, under its own analysis in this technical report, which, by the way, is like a report you'd submit to the Securities and Exchange Commission, and you'd show it to all your investors. I think a really interesting fact that hopefully some of the justices were picking up on was that PolyMet's current project really isn't profitable. The assumptions in the technical report in support of that project are questionable because they assume a price of copper that hasn't been the price of copper for many, many years now. And so the technical report itself undermined PolyMet's case that this is the permit that it's going to be able to operate under for the foreseeable future. That's just not the case. Some of the justices seem to be getting them.
Yeah. How about you, Keri? Did anything jump out from you? I'm interested to see how this case looks from further afield. We've been working on this PolyMet thing for years and years and years.
I did find it very interesting that the judges were, many of them were very pragmatic in their questions. They wanted to know exactly how the agency would apply the rule of determining whether a permit application for a facility that has not yet been built, whether that was a sham permitting application or not. And also were very interested in knowing sort of what protections are in place for the public if sham permitting is allowed to proceed, and if it's acceptable for the agency to just address the problem after the fact. And Evan did a really nice job of coming back and explaining that this really has a huge impact, because if a facility is already intending to build a larger facility that actually would be major and subject to the much more protective Clean Air Act requirements governing major sources, that needs to be dealt with at the outset, before the project is already underway and before there are facts on the ground that make it very difficult for the agency to be able to go back and say that something different needs to be done with this facility, or that it shouldn't have been constructed at all. And that's the reason it's a pre-construction review program, is that it might turn out, based on the analyses that are required under the Clean Air Act, that the way this facility is designed and the impact that it will have on air quality is simply not acceptable and insufficient for protecting public health and the environment in the area. And that's a decision that really needs to be made before construction and before any environmental and public health harm has already occurred. So I did, going into this, I expected the judges to be a little bit more immersed in the procedural aspects of the case. And by and large, they were interested in the nuts and bolts of how the agency applies its air quality regulations and how that impacts a planned facility. So I thought it was actually, for me, a much more interesting argument than I anticipated, because it wasn't so bogged down in a lot of the sort of administrative law details that most people don't follow very closely.
Yeah, no, I totally agree. Had the same reaction. Evan, what do you want to say?
What's really interesting about what Keri is saying is that, the attorney for PCA is not their usual attorney. I mean, normally you would have the Attorney General's office on this case explaining how these cases could explain, past practice, different things that they're familiar with. But Attorney Schilling doesn't work for the AG's office. She's private counsel from the outside. So it was a little bit different perspective, I think, that was apparent in this case.
Right. I want to remind people and encourage you also to ask us questions. You can use the Q&A function on the webinar. If you hover, you'll see a couple bubbles in the middle on the bottom of your screen, and you can put your questions there. And there are a couple questions here that we have. So the question is, what would you say is the weakest part of the argument, PolyMet's argument, and then also our argument?
Well, I'll tell you what I think. I think the weakest part of their argument is that they did really analyze this, because it's pretty clear that they didn't. They just looked at it for a couple days. They wrote a very short letter and didn't engage with any of the things that we sent, particularly any of the evidence of really the economics of this. Or with the EPA guidance document. That's the standard for how you determine if a permit is a sham. I think the weakest thing for us is there was nothing to point to as to precedent. I mean, this is really a case of first impression for the country on what does that guidance document mean. There's been very, very little litigation about this in a similar case. Yeah.
So basically the facts here are that they started to look at this issue when in December 12th or something.
I think our letter was December 13th. They wrote back on December 19th, and the permit came out on December 20.
So they looked at it for all of 5 days, possibly.
Yeah.
Keri, I'm wondering from your perspective, I mean, you have worked on air permitting from a lot of different sides, I guess. And what do you feel like the agency really should have done given EPA's guidance on this sham permitting issue?
Well, as it turns out, if you read the briefs closely, PolyMet admits that they want to build a bigger facility. I mean, they say it, right? They say, oh, we're not sure if we're going to be able to do it yet. But that's what they want. They're working toward that. And then the state in their brief never says PolyMet's not going to build a bigger facility. They just say, well, nothing's certain. And that's not the standard. Because of course, it can't, until you get a new source review permit for your project, it can't be certain that you're going to do it. So certainty is plainly not the test for whether or not they have an intent to make a bigger facility. So in this situation, there's all, like, let's start with the basic question of PolyMet. Do you intend to build a bigger project? Like, what have you done at this point to make that a reality? And then just start going into the type of ask for the type of documents that a company would normally file and the inquiries that they would make that would lead them down the road to actually, doing a much bigger facility, an expanded facility. And in this situation, they didn't ask any of that. They pretty much looked at the technical report that had been submitted to Canadian regulators, said that it wasn't definitive about the facility being bigger, and pretty much they just relied on the idea of, well, if it could be economical to build the smaller facility, then that's good enough for us, and we'll let it get built and we'll deal with the rest in enforcement. And that is simply, that's insufficient. They need to hold their applicants to a higher standard and at least come up with a reasoned explanation for why it really is conjectural right now and not part of a reasonably firm business plan that's what they're intending to do.
Mm-hmm. What about you, Ann? So, I mean, you advised PCA for many years, maybe not so much on air permitting, but is this like a typical response from the agency to take 5 days to address a serious issue and then send a letter?
It really isn't. I would have to say, I agree with Keri. What was really the most disappointing thing here is that a significant issue was brought to PCA's attention, and PCA did almost nothing about it. Didn't take it seriously at all. It seemed clear that the permit was in the pipeline and they didn't want anything to stop its issuance. And even taking a couple weeks and going back and looking at the documents that we had submitted to them over the summer, that was apparently too much work and not something that the agency was willing to do. So, and they didn't even change their findings to address this issue. They took it so not seriously that they didn't even put it in their findings. They just sent an informal letter of a couple of paragraphs saying, well, this document contains disclaimers, therefore PolyMet's expansion is speculative. Well, the document contains disclaimers about everything. The document contains disclaimers about the 32,000 ton per day mine, which is what PolyMet is proposing to build. I mean, like Keri said, everything is uncertain right now, whether they're going to even be able to build that mine. So certainty is not the test, and it's very disappointing to me that PCA didn't take the opportunity that it had before it issued this permit to say, well, okay, well, we missed what you sent us over the summer, but now we're going to go back and take it seriously. And I think the really telling part of the story of this case with regard to this issue is that when Evan got the administrative record from PCA, which is this compilation of documents that PCA submits to the court and says, this is what we looked at when we made our decision. PCA included nothing. They didn't even include the letter that we sent December 13th. They didn't include the technical report. So Evan had to negotiate with PCA, and PCA eventually said, oh, well, okay, we'll put those in there. But then they refused to put in the material that we had submitted to them over the summer, which we had referenced. They refused to put in our request that they stay their actions on the permits, which came in the fall, because we again referenced with emphasis. And the emphasis didn't come from us. It came from DNR. DNR's own expert had looked at the technical report by that time and said the exact same thing that our expert had said earlier in the summer, which is that the 32,000 ton per day case is sub-economic and really very unlikely to be developed. Said the same thing. PCA wouldn't even put that in the record. So some things amiss, in my opinion, with the way the agency handled this case, and it was very disappointing to me as a former advisor.
Interesting. You touched on a number of things there that I want to come back to, but we're also getting a bunch of questions in the Q&A. So let me ask a couple of these. Maybe this is good for you, Evan. Could you explain briefly how you discovered that PolyMet intended to expand its operation?
Well, we had suspected this for a long time. I mean, there are documents that you can look at that go back to 2009, 2013, that talk about the potential profit opportunity of mining more metal faster. But this particular one, actually, I think it was in the office before I started. I don't know how we actually got it. And do you know how we got the technical report? I mean, it was filed with the Securities and Exchange Commission and also in Canada and Toronto. So it's not a secret, but I'm not sure how we found it.
Well, we were aware that it was likely that PolyMet would release a new technical report because they're required to do that under Canadian securities regulations. And in fact, in comments to the Department of Natural Resources during their permitting process, the commenters had argued that the department should wait until the new technical report was released. So we were well aware that it was coming, and it's easy to obtain them online.
Yeah. Here's a question about asbestos-like fibers. So people will recall that during the reserve mining battles, now North Shore, the agency became aware of these fibers that are like asbestos, and there's a lot of concern about them having bad health impacts like asbestos could. The question is whether there is any emissions limit or specification to monitor these elongated mineral particles that are asbestos-like. I'm not sure the answer.
I do know the answer. So this concern was brought up during the permitting process and in the environmental review. And so PCA was well aware that PolyMet would probably be mining in areas where the asbestos like minerals would be found, because they are right next door, hard by the Peter Mitchell pit, which is North Shore Mining's primary source of ore. And that's where these mineral particles are known to be. And so PCA did put some conditions in the permit that were heightened, I think, monitoring for these particles. But frankly, you know, that is part of the rolling of the dice with this facility. It is very likely that, you know, the particulate matter that will be generated will in part contain some of these asbestiform particles. And so it just is a heightened risk, and it's why the level of particulate control is so important at this facility as well as North Shore, because North Shore, they have to have a heightened level of particulate control as well. But by being a synthetic miner permit, of course, you get by with not necessarily the best available control technology.
So Keri mentioned earlier that she thought the argument would be a lot about procedure, Minnesota procedure. There's a question here about the difference between remanding and reversing and how PolyMet's attorney was focused on that. Could you explain what the issue was and how it came up in the case?
Sure. When a case like this, an administrative law case, goes from an agency decision to an appellate court in Minnesota, the court has to look at what the agency did. And there's this line of cases that we relied on that says that if the agency didn't make sufficient factual findings for the court to understand what the agency did and why, one remedy that the court can do is send it back and say, you know, you didn't really establish these facts. We can't make the facts for you. Fact finding is for the agency to do. So we're going to send it back for you to do that. And then if there's still an appellate issue, we'll review it again.
And that's essentially what the Court of Appeals did in this case, right?
Exactly. That's what the Court of Appeals did in this case.
Okay, so that's the remanding part. What's the other version of what they could do?
If an agency makes a decision that the court decides is, I want to say wrong, but it's wrong legally. It's either against the law, or it's not based on the evidence in the case, or it's what we call arbitrary and capricious, which means that there was no real reason for it. They didn't explain themselves, and the decision doesn't make any sense. Is that sort of the way I think about it? Is the court can then reverse and say that the agency made an error of law, send it back, and then that permit is void. They would have to start again from scratch with a new permit application.
Well, another thing that we heard a lot of was sort of this presumption that an agency's decision is correct, and that the court that's reviewing the agency has to be deferential to the agency's decision. What were your guys' responses to or reactions to questions around that?
Yeah, I mean, it's a really legalistic part of this case, which is, you know, what's the level of deference that a court needs to give to an agency's decision on like a difficult question, or really any question. And the rule is not that the court can say, well, if we were us, we would have decided differently. That's sort of a review, what we call de novo, which means they get to just do it again as if the agency had never done it. But all of these agencies' decisions in the vein that we're talking about require the court to give deference to the agency, meaning that if the agency's decision is, you know, reasonable, if it's rational, if it makes sense, if there's evidence that supports it, even if we think they could have made a different decision, we're not going to disturb that. We're going to defer to their choice of action.
Here's a good question for
help?
you, Keri. Yeah, no, thanks. Specific about the Federal Clean Air Act, there were several references to the look-back provision. Could you please elaborate? What is the look-back provision? How does that work? Why is it relevant here?
Okay, so the look-back provision is simply, the way the Clean Air Act is set up is, at least the regulatory provisions are set up, is that if a source comes in and takes a limit, so they are what they call a synthetic minor, like without the limit, they would be major, but they take this limit, so they become synthetic minors. If it later turns out, through no real fault of their own, it's just circumstances changed, maybe things became uneconomical, maybe they incorrectly estimated their emissions and it turns out they can't possibly be minor, then they can have the limit removed. But when they do that, the state has to, or the permitting authority, whoever, federal or state, has to re-permit this facility as though they'd never been constructed. And so this is a powerful provision because it does help guard against sources just, you know, getting rid of limits that they have previously committed to comply with. But it's obviously not as good as applying new source review, you know, requirements right at the outset, as we already discussed on this call, that you've still got an existing facility already built with people already employed there, funding already in place, business contracts already there. And so your chances of getting that, you know, honestly, what I've sometimes seen happen in that situation is that you end up getting very bad technology decisions because the state agency will be under a lot of pressure not to require a major retrofit of the facility. And so they'll just come up with this idea that, well, it's not economical, and sometimes really bad, really poorly reasoned decisions that it's not economical for that to happen and whatnot. And so what we were hearing from the state in this case is that they're saying, well, that's our backup, you know, that's our provision that's there. So if the limit ever goes away, you know, we'll fix it, and it'll just go back to the way it was before. And so the argument in our briefs was that, you know, absolutely not. That's not a get out of jail free card for somebody who already knows they want to build a major source at the time of construction. That's sort of the best you can do to remedy a situation when it turns out that your original plans to be a minor source aren't going to work out. Great,
thanks for that explanation. Some more questions here, and again, I'll invite people to put their questions into the Q&A function. It's at the bottom of your screen. This is a good one. We can't quite figure it out, but why was Justice Thiessen not participating? So Justice Thiessen is recusing himself from the PolyMet cases, and we don't know why. Do you guys want to speculate? No?
I don't know, Kevin.
I mean, the only thing we could think of is, you know, for some reason, maybe he owns stock in the company, but that seems unlikely. I don't know. It's a really good question.
Yeah. Another question here. The court seemed to be siding with PolyMet that our December 13th letter was too late. Reactions to that?
I don't know if they were siding with PolyMet. You know, part of the purpose of oral argument is for the justices to really probe and challenge the attorneys on some of their arguments. It doesn't necessarily mean that they disagree. I mean, sometimes they'll ask a question because they agree with you. They just want to make sure of something, or, you know, to understand it more, to send a signal in some way. So, you know, I don't know. I mean, we did what we did. We sent them the documents when we had them. And ultimately, the burden's on the agency to really take care of this problem. They're the ones who have the burden to decide if the permit's a sham or not. You know, it's not us who have to make the case.
Mm-hmm. Keri, you mentioned that you'd been referencing our Court of Appeals win in this case in some of your other work. I'm just wondering if you can talk a little bit about the national significance of having you know, a Minnesota Supreme Court case on sham permitting. If we win, how could that be helpful? Yeah, what would this mean?
Sure. Well, I mean, from my perspective, when I'm reviewing an air pollution permit and I find a sham permitting issue, if I can point to the Supreme Court of Minnesota as upholding this inquiry as something that the agency has a burden of responding to the facts and engaging in a reasonable inquiry, that's going to be very helpful across the country in applying these permit requirements. And huge numbers of facilities get out of the major source requirements and instead just comply with minor source requirements, which often are very little. You know, it can be the difference for some facilities between installing pollution controls that are really effective and reduce pollution by 99% and not installing any pollution controls really at all. It can be that dramatic. I do want to, I'd seen this question sort of poked up high in the question list, and I've been thinking about it since I saw it. And I think something else that's a little more subtle, but is really important, is how a case like this can change industry behavior. Because very few air pollution permits in this country are actually scrutinized by the public. It's very complicated, tricky. For minor permits like this, you don't necessarily always even get an opportunity to comment. In the state of Georgia, they will not let you have public comment on a permit like this. You see the application, wow, and after that, it's done. You don't get to look at the permit itself. So what you really want to see is the industry behaving differently. And if the industry knows that their permit might get totally stalled out and remanded and construction delayed because questions came up as to whether they're trying to circumvent new source review and build a major source when, you know, under minor source requirements, there's a really good chance that if that's really the road they're going down, they're going to apply for a major source permit at the beginning. And that's what we really want to see happening here is is a change to industry behavior so you achieve widespread compliance, and not just making a little bit easier if you happen to find out that there's a problem to force compliance.
Yeah, great. Evan, where do we go from here? What's going to happen next?
Well, now we wait. I've been working on this case for 2 years, so it's sort of it's a relief in a sense not to be waiting for the argument, but now we're just waiting for the answer. And the court has a couple options. I mean, they can affirm the Court of Appeals, and which is what we're seeking. And in that case, this will go back to the PCA. They'll have to open the record and review all of these documents. And I hope that they're going to review everything we sent, plus, whatever we have now. The other side is they could reverse and say that the Court of Appeals had no reason to remand, and in that case, the permit would stand, and we would, whatever happens, we're going to continue following the PolyMet case, and for purposes of this call, we're going to be following the air permit, and what happens if any sort of changes to it are proposed ever, we'll be on it.
Great. And just as a reminder to folks, we have multiple cases pending on PolyMet's various permits, including their permit to mine from the DNR that was argued last month at the Supreme Court. And there's also an appeal pending on the water permit that's been stayed now while the DNR case is decided by the Minnesota Supreme Court. So lots of things to watch and be decided yet for PolyMet. I see that we are at our 45 minutes, so I just want to thank everybody again for joining us, and thank the panelists. Keri, particularly you, for joining us from Georgia. Good luck with the election results down there. Hopefully we'll know something soon. And thanks Evan and Ann, and then particularly everybody who's online today watching. You know that we've devoted enormous resources and time to opposing PolyMet's dangerous sulfide mining proposal, and we Minnesotans have to get this one right. So we're counting on you to continue to help us with this fight. We can't do it without your support, and I invite that continued support from you. If you are as amazed as I am by these fabulous advocates, you can go now to www.mncenter.org, and there you'll find a donate button. We appreciate your support, and we really thank you for joining us today. Enjoy the rest of the nice sunny day.
Can I just add before you go? I just want to say thank you to everyone out there. I do think about our supporters and all of our clients and people who really care about PolyMet when I'm preparing for this. It energizes me and keeps me going. And I also want to thank Keri for helping me hone my arguments on this case. And I appreciate your amicus brief on this. It was really important. So thanks, Keri.
Yeah, absolutely. All right, thanks everybody. See you.